Welcome to Learn Law with Saiful. Today's topic is trial in absentia, or trial of an accused in their absence, under Bangladesh criminal law. We'll discuss when it happens, how it works, and what rights the accused has. What is trial in absentia? A trial in absentia means a criminal trial conducted without the accused being present in court. In Bangladesh, this is allowed in limited and special circumstances, especially when the accused intentionally avoids the court. The accused is absconding. The court believes the person won't return voluntarily. Legal basis. Section 339B of CrPC, introduced through amendment. Applicable only to sessions cases. Also guided by court rulings and procedural fairness. Steps before trial in absentia. 1. Court must issue warrant of arrest. 2. Police must try to arrest the accused. 3. Court must publish notice in newspaper. 4. Time is given to appear voluntarily. 5. If still absent, court may proceed ex parte. Accused rights are protected. The accused can appear later and apply for retrial. The trial must follow natural justice. No conviction should be made without proper evidence. Why it's used? To prevent delay of justice. When accused is a fugitive or in hiding. Especially in serious criminal cases like murder, terrorism, or corruption. Limitations and safeguards. Should not be used as punishment. Court must ensure the trial is fair and transparent. Judgment must be based on proper evidence. Real example, optional. You may refer to a public case like war crimes trials where some trials were conducted in absentia due to the accused staying abroad or hiding. Thanks for watching Learn Law with Saiful. Please like, comment, share, and subscribe.